Definition of common law. The term common law can have a number of different meanings depending on its context. In a very broad sense, the term can mean the legal system and habits of legal thought that Englishmen have evolved. In this sense, it is contrasted with systems of law derived from Roman law. In a narrower sense, it refers to those laws that are common to the whole of the kingdom and derived from common usage and custom. In this sense, it contrasts with whatever is particular, extraordinary, and special, whether that distinctiveness is due to geographical, political, or other factors. For example, common law is not local law or custom, nor is it mercantile or canon, that is, ecclesiastical law, though the term is derived from the usage of the canonists. Common law derives largely from ancient usage and precedent, though it is anachronistic to apply the term to any period earlier than the 13th century. Common law contrasts with statute law and often means that part of English law, including equity, which is unenacted, especially that contained in the decisions of the courts as opposed to acts of parliament and subordinate legislation. Although generally common law is in origin customary law, it does, however, comprehend some principles that did not originate in legislation. On the other hand, common law is contrasted with equity, which was administered in the Court of Chancery. Equity is applied where common law and the precedents established under it are not able to provide a framework for justice in particular or special circumstances. It is clear from this that a simple, trouble-free definition of common law is not easy. Writing of the 12th and 13th centuries, Arthur Hogue defines common law in a broad sense as the body of rules prescribing social conduct and justiciable in the royal courts of England. For our purposes, we shall use this definition of common law, since our concern is not with a more narrow or particular definition and understanding of common law, but rather with the influence of Christianity and biblical principles of justice upon the development of English law. This definition does not embrace the Court of Chancery, which was the principal court of equity, or Star Chamber. The origin of common law. The dating of the development of common law usually begins with the Norman Conquest. Over the 2 centuries that followed 1066, the Norman and Angevin kings slowly established a system of royal courts that administered justice across the whole realm, according to a common body of laws. Prior to this development, the principal courts in existence were the communal courts of shire and hundred and the feudal courts of the landowners. However, the sources of English common law go back to pre-Norman times and were embodied in local customs, which at many points differed between the kingdoms of Wessex, Mercia and Danelaw, and the dooms of the English kings going back to Alfred. As a result of the Norman conquest and the establishment of royal courts throughout the kingdom over the following centuries, these local customs were unified under one system of law common to all men, later called the common law. The jurisdiction of the shire, hundred and feudal courts was not abolished formally, but rather declined as the jurisdiction of the royal courts increased. Before looking at the emergence of the common law during this period, we shall look at the influence of Christianity and biblical law on English law prior to the Norman conquest.